This is the Hidden Killers Podcast with Tony Bruschi and continuing coverage of the case against Bryan Kohberger.
So here's where things just got a whole lot more real in the Bryan Kohberger case. On April 24th, the defense, they swung big. They tried to take the death penalty off the table. Their argument? That Kohberger, recently diagnosed with Autism Spectrum Disorder, ASD, level 1 to be exact. We have info, we have the receipts that he has the diagnosis recently, should be categorically ineligible for capital punishment. According to the Kohberger camp. Just like we shouldn't hear witnesses or evidence in the case, things that make sense. They leaned into that diagnosis like it was their legal escape hatch, citing precedent, psychology, and tried to place ASD on the same shelf as intellectual disability under Atkins versus Virginia, which blocks the execution of individuals with significant cognitive impairments. The problem is that's not what ASD is. Sorry. You kind of, you're categorizing it into a arena that it ain't. It's like saying, okay, you know what? It's a nice day. We're excited for this. It's a football game. And then you bring a bunch of baseball players out to the field. We're like, what? This is a football game. Like, well, I know. We know that. But we thought maybe you'd like this. It's not how that works. And the court did not bite. Not only did the judge reject the motion, he laid out exactly why this wasn't going to fly, not just in this case, but likely not in any Idaho courtroom moving forward. Kohberger's autism, the court ruled, doesn't qualify him for the kind of protection Atkins provides. Why? Because autism spectrum disorder, even at its most challenging levels, is not the same thing as an intellectual disability under the law. They're both neurological conditions, sure, but legally and clinically, they live in two different zip codes. Now, we have a lot to go through in this video today and this audio. So I want to hear your thoughts in the comments on YouTube. Please leave them there. Would love to hear them. If you're listening to us on any podcast platform, be sure to check out our YouTube channel. Just search Hidden Killers with Tony Bruschi, and you'll find us there in video form, in Technicolor. You're like, what's Technicolor? Is that? No, it's how they used to say color television. If you drive by like an old crappy motel that's probably filled with a lot of sex workers and meth and all sorts of fun things, bed bugs, things you don't want, they sometimes have a sign that still says Technicolor TVs. You know you're at a classy place then. So leave me your comments in the comment section on YouTube, and be sure to press subscribe right now, wherever you're listening or watching us, so you don't miss any of our coverage. The defense's case leaned heavily on reports from Dr. Rachel Orr, a clinical neuropsychologist who evaluated Kohberger and confirmed the diagnosis. She noted a lot of what you'd expect from level 1 ASD profiles, some rigid thinking, awkward social interactions, flat affect, kind of quirks that might make someone come across as off to the average person. But none of those traits, none, touch the threshold for impaired intellectual functioning. In fact, Kohberger tested with a full IQ scale on that scale of 119. That puts him well above average. Doesn't make him intellectually disabled. Makes him fully aware of what he's doing and probably able to do a lot of things better than most. Not just he's doing fine territory, but he could help your kids in calculus territory. This is a guy who has a bachelor's, a master's, and was in the middle of a PhD program when he was arrested. His GPA in that master's program, a perfect 4.0. And according to another expert report from forensic psychiatrist Dr. Eileen Ryan, Kohberger showed no signs of formal thought disorder, no language impairment, no confusion about the trial, the charges, or the possible outcomes. In fact, Dr. Ryan said he fully understood the proceedings and the roles of everyone in that courtroom. Of course he does. So not only is he mentally competent, he's likely one of the most academically accomplished defendants to face capital murder in recent memory. Now, none of that is to say Kohberger's not neurodivergent. The court didn't dispute the diagnosis of autism, but it did make clear that a diagnosis alone, especially one that lacks any intellectual or developmental impairment, doesn't automatically open the door to constitutional exemption. Of course not. And when the defense tried to argue that the autism somehow made Kohberger less culpable, less able to function, and more at risk of being wrongfully sentenced to death, the court's response was essentially, "You're reaching." And here's where it gets even tougher for the defense. They tried to pivot with a second argument, one that didn't hinge on national precedent or medical definitions. They claimed that the intense media coverage surrounding Kohberger's autism had created an environment so saturated with bias that a fair sentencing was impossible. In other words, they argued that the media had turned Kohberger's neurodivergence into a sideshow, highlighting his so-called robotic demeanor, his lack of facial affect, his cold stare. All the classic tropes the public tends to associate with the creepy loner archetype, which he is. And according to the defense, all of that coverage would make it impossible for a jury to consider his autism as a legitimate mitigating factor in sentencing. The public, they argued, has already decided that those traits weren't a sign of mental difference. They were a sign of guilt. I don't think so. I don't think anybody looks at it as a sign of guilt. But look, everybody knows those sorts of creepy people out there. Sometimes you end up hearing about them later in the news, like, oh, they did that. Yeah, I'm not surprised about that one. Because guess what? There's a lot of undiagnosed people out there. And Bryan finally seems to have gotten diagnosed. They kind of operate out of some of the same playbooks. And no way am I saying everyone with autism is out there killing people. But yeah, that can affect your social skills, how you relate to others, empathy, all of that. It just depends where you are on the spectrum, because one person on the spectrum can be super empathetic and the other can have like little to none. That's why it's called a spectrum. But again, the court was not having it. The judge said in so many words that while media scrutiny might be unfortunate, it wasn't a constitutional issue. There's no legal precedent that says media coverage of mental conditions is grounds for striking the death penalty. And more importantly, that's what voir dire is for. That's why you question jurors. That's why you screen them. The court noted that if a potential juror can't separate media impressions from evidence, they can be removed. If they get selected and later show bias, there are mechanisms to address that. But you can't scrap the state's ability to pursue a death sentence just because Twitter's been loud and the Dateline specials haven't been subtle. And the court made one more point, kind of a quietly devastating one for the defense. The idea that Kohberger's autism would prevent him from assisting in his own defense. That was flat out rejected. The court noted that not only is he capable of understanding the process, he's been actively involved in reviewing evidence, speaking with attorneys, and shaping his defense strategy. This wasn't a passive participant. This was a guy fully engaged in his own legal battle. And to make matters worse for the defense, the court pointed out that autism spectrum disorder is just that, a spectrum. And that means its symptoms, implications, impacts, everything. They vary wildly from person to person. There's no uniform experience for autism. You can't lump everyone under the same umbrella and say that they all face the same legal vulnerabilities. That variability is exactly why the law doesn't treat ASD the same way it treats intellectual disabilities. There's no IQ test that confirms it, no singular benchmark. It's too broad, too individualized, and that makes it a tough sell when you're arguing for categorical exemption from the harshest punishment in the justice system. So where does that leave us? Well, it leaves the death penalty very much still on the table. The court's message was crystal clear. Kohberger's diagnosis of ASD doesn't disqualify him from capital punishment. And the court isn't going to start carving out new legal categories unless and until the Supreme Court tells them to. This wasn't just a rejection, it was a line in the sand. Autism alone, at least in Idaho, is not going to be your get out of lethal injection card or firing squad. And let's not forget the symbolic weight of the ruling. This wasn't some minor pre-trial motion about filling deadlines or scheduling disputes. This was a major constitutional question. This was the defense swinging for the fences, trying to chip away at the prosecution's most powerful tool, the threat of execution. And it didn't just fail, it failed definitively. What this does, beyond just shaping the future of Kohberger's case, is reinforce a pretty stark message. Neurodivergence, unless it severely impairs intellect or functioning, is not going to offer protection in capital cases. And for the defense, that means the road ahead just got a whole lot narrower. Because if you can't eliminate the death penalty, your best shot is undermining the evidence. That brings us to what the court had to say about expert witnesses, forensic analysis, and exactly who gets to tell the story of that night in court. That's what we're about to get into right now. It's one thing to fight the charges. It's another to fight the evidence itself. And in the Bryan Kohberger case, the defense has made it plenty clear that they'd prefer a smaller trial, one with fewer experts, fewer charts, fewer explanations of things like tower triangulation or digital forensics. The fewer pieces a jury hears, the fewer they have to assemble. But this week, the judge made it clear the jury is going to hear a lot. On April 24th, the court ruled against the defense's motion to exclude or limit a wide slate of expert witnesses brought forward by the state. The argument from the defense was mostly procedural. They claimed many of the discoveries were vague. I like to look at stars on nights where you can't see the stars. Incomplete, and lacked the kind of detailed methodology required by Idaho's discovery rules. Essentially, they said the prosecution didn't fully outline how these experts reached their conclusions, so their testimony would be thrown out. Probably not a surprise to Ann Taylor, but hey, it's got to try. But the judge wasn't persuaded. The court found that any gaps or ambiguities in the expert disclosures weren't violations. They were opportunities for cross-examination. If the defense thought the conclusions were flawed, they could challenge them during trial. What they couldn't do was erase them altogether before the jury even had a chance to hear them. And with that ruling, the prosecution narrative just got sharper. You know, like the blade that Kohberger bought on Amazon. First up, the state's cell phone expert, FBI Special Agent Nicholas Balance. He's part of the agency's Cellular Analysis Survey Team, or CAST for short. If you're not familiar, CAST agents specialize in mapping cell phone movements using tower pings, call detail records, and signal propagation analysis. In this case, Balance analyzed records from AT&T tied to Kohberger, as well as to Madison Mogen and Xana Kernodle, two of the victims. He also conducted what's called drive testing, which essentially involves replicating signal routes in real time to eliminate phone locations at specific times. Balance's reports, which runs 30 pages, lays out when and where Kohberger's phone allegedly connected to various towers. One key point in that report: just before the murders, around 2:47 a.m. on November 13th, 2022, Kohberger's phone reportedly pinged a tower southeast of his Pullman apartment. Then at 2:54 a.m., the phone went dark, cutting off all connection to the network. According to Balance, that blackout window matters. It suggests intentional disabling of the phone or being in a location without service, both of which are relevant to the timeline. The defense brought in their own cell phone expert, Cy-Ray, who, by the way, on the weekends can fix that cracked screen for you for only $99. Okay, I'm making that part out. I am, unless he really does that. in which he does, well, then I'm sure he does a lovely job. To challenge Balance's findings, Ray claimed Balance's disclosures were missing key pieces, like analysis of certain handoff data or documentation for how the drive testing was performed. He also argued that the state didn't explain why certain tower coverage maps were omitted. Ray's take was that this missing data could be exculpatory, at the very least critical to assessing the reliability of Balance's conclusions. The court acknowledged the criticism but found that Balance had disclosed enough to satisfy the legal standard. The cast report laid out the facts, the methodology, and the conclusions. And while it may not have spelled out every microscopic step, the judge said that wasn't required under Rule 16. If Ray had an issue with the methods, he can bring that up during cross. But the jury will get to hear Balance's full testimony. Then there's the digital forensic duo, Heather and Jared Bernhardt from Cellbrite. These are the folks who looked into Kohberger's phone and school-issued computer. Their conclusion: there were gaps, not just random empty spaces, but chunks of time where data simply wasn't there. Gaps in the system logs, gaps in the Chrome browser history, missing event logs during key dates like November 11th through the 16th. The Bernhardt's professional opinion: these gaps were abnormal. They suggest the possibility of data wiping, private browsing, or use of anti-forensic tools to scrub activity. The defense argued that the term abnormal was too vague, and that the state didn't properly explain what habit they were comparing Kohberger's behavior to. But the court pointed out something important. Nowhere in the disclosures did the Bernhardts actually use habit analysis in the legal sense. They were simply pointing to what they observed, a break from expected system behavior. That's a technical finding, not a psychological profile. Their report backed that up with specifics. They found deleted logs, evidence of possible file cleanup, and behavior inconsistent with routine academic device usage. That's not speculations, that's just analysis. And again, if the defense thinks it's flawed, they can push back during trial. But the jury is going to hear it. Now, zooming out from the technical side, the court also approved testimony from Michael Douglas, not the actor, a forensic accountant with the FBI. Douglas reviewed Kohberger's financial records, debit card usage, and ATM withdrawals, and what he found was a shift in behavior around the time of the murders. For November 10th, Kohberger was using his debit card regularly. After that, it stops. Instead, he starts pulling out cash. That's interesting. Wonder why that is. Can't track cash as easily as you could a debit card or a credit card. Douglas didn't offer a psychological profile or suggest why the change happened. He just documented the shift. And the judge made it clear factual observations about spending behaviors don't need to be paired with a motive to be admissible. The data speaks for itself. The pattern, the dates, the transaction, that's all fair game to the jury. They can interpret it. And then there's Darren Gilbertson. He's the lead detective for the Idaho State Police, and he did something that the defense probably wishes he hadn't. He ran timed walkthroughs at 112 King Road, the scene of the murders. Gilbertson retraced the route a suspect would have to take to carry out the killings, using different paces and paths and factoring in the estimated number of stab wounds. His conclusion? Depending on the route and speed, the entire crime could be committed by one person in approximately 2 to 4 minutes. The defense tried to block Gilbertson's testimony, saying he wasn't a qualified expert in timed runs. They also said the walkthrough was flawed because Gilbertson was familiar with the house. It had already been vacated, and importantly, the defense can't repeat the test because the house has since been torn down. But the judge disagreed. The test didn't require specialized credentials. Gilbertson is the lead investigator, and timing and route through a crime scene isn't outside the scope of law enforcement work. And while the house was later demolished, that happened after Gilbertson's walkthrough, after his report was disclosed. If the defense wanted to run their own experiment, they did have the opportunity. Finally, there's Dr. Gary Dawson. His role is a bit more surgical, no pun intended. He's a rebuttal expert brought in specifically to challenge the defense's argument that multiple attackers must have been involved. In part because Madison Mogen and Kaylee Gonzalez were reportedly in the same bed at the time of the attack. The defense's expert, Brent Turvey, suggested that Mogen would have to put up a fight and that two people would have been needed to control the scene. Dawson, however, analyzed toxology data and concluded that Mogen was markedly intoxicated at the time of her death. His opinion is that she would not have been capable of meaningful resistance. That conclusion doesn't contradict the facts, it contextualizes them. And the court agreed that this kind of rebuttal was relevant and admissible, depending on how the defense experts present their case at trial. So what does this all mean? It means the jury won't be going into this trial with a blank canvas. They'll hear from analysts, forensic scientists, investigators, and doctors, each adding another layer to the prosecution's case. The defense tried to keep some of that out. They argued that the rules weren't followed, that the disclosures weren't specific enough, but the court made a clear distinction. Imperfect disclosure is not the same as inadmissible testimony. And you're just kind of full of shit. You can say that this is that, but it doesn't mean it's that. And what's even more telling is the pattern. The defense isn't just arguing innocence. They're trying to shrink the case, narrow the scope, limit the exposure. But if all of that we just talked about was about the court refusing to take the death penalty off the table, what we're about to jump into is the court refusing to take the story off the record. The jury is going to hear the full weight of the prosecution's evidence, and that includes what was found, when it was found, and who says it matters. It is easy to look back and say that someone should have done something in a moment of chaos, especially when you're holding the privilege of hindsight in one hand and a court transcript in the other. But when you're actually in it, when something is off but you can't name it, when something terrifying is happening in real time, but your brain has not caught up yet, you don't always act the way that the textbook says you will. Or what a podcaster says you will, or what Jim Bob down the road says you will, or what whoever says you will. Especially not the women sending in panties and letters to Kohberger says you will. And that's exactly what makes the roommate message and the 911 call from the night of the University of Idaho murder so important and also so human. This past week, the court handed down a detailed ruling on what the jury will and won't hear regarding communications from the two surviving roommates, DM and BF. In the early hours of November 13th, 2022, these are the women who were inside the house at 112 King Road while four of their friends were killed just a floor above. And for months, speculation about what they saw, when they saw it, and what they did after has swirled in public forums like wildfire. In court, however, the court is, however, only interested in what's legally relevant. More importantly, what's admissible. Let's start with the messages. Between 4:22 and 4:26 a.m., DM and BF exchanged a flurry of texts that are now cleared to be shown to the jury. These weren't long, reflective texts. They were short, fragmented, and anxious. Exactly the kind of rapid, in-the-moment burst you'd expect when something's wrong, but your body hasn't processed just how wrong yet. One of the texts from DM reads, "No one is answering." And then, "I'm really confused, RN." Another, "What's going on?" And then the shift comes. She starts describing what she saw. No, it's like ski mask almost. Then a bit more detailed. Like he had something over his head and a little mouth. She follows it with, "Bethany, I'm not kidding. I'm so freaked out." On the other end, BF replies, "Yeah, dude, WTF." Then Xana was wearing all black. And in a final desperate attempt to find safety and something that makes sense here, she urges, "Come to my room. Run down here." These messages now fall under two legal exceptions to the hearsay rule: present sense impression and excited unutterance. Translation: the court believes these messages were made either during or immediately after the event DM perceived, and while she was still under the stress of that perception. There's no time to concoct a story here. The law recognizes that people in distress usually don't have the luxury or the motive to fabricate. They react. And that's what makes these messages legally relevant. But it's not just about proving what they said. It's about painting a picture of what that house felt like in those early morning hours. Confusion, fear, silence. DM had seen a masked figure. She didn't know what to make of it. She didn't know people were dead yet. She just knew something wasn't right. And she was scared enough to send a string of panic texts and then ran to BF's room for safety. That isn't calm behavior. It's the kind of panic that doesn't always read as panic when you're still trying to believe that things are normal. Now, 8 hours later, around 11:56 a.m., the 911 call was made. And this call has become one of the most scrutinized pieces of the entire case. The defense wanted to suppress parts of it, of course. The prosecution wanted the whole thing in. The judge landed somewhere in the middle. The audio of the 911 call will be allowed to play for the jury. The official transcript will also be shown alongside it to help the jurors follow on what's being said. But not everything in the call gets a free pass. Some portions, especially statements that qualify as hearsay, aren't covered by exemptions. And those will be redacted unless the state lays the proper foundation at trial, and there's still plenty of time for that. So while the jury will hear the emotion, the breathing, the confusion, they won't hear statements that speculate about events unless they meet the evidentiary bar. Here's what's in the call. BF is the first voice. She's saying her voice is strained, or you can hear her voice being strained. She tells the dispatcher, "Something is happening. Something's happened in our house, and we don't know what," but she can't continue. The phone gets passed around to others, DM, a friend named HJ, and an unidentified female. There's heavy breathing, sobbing, fragments of panic. One voice says something about someone being passed out, and another mentions someone who was drunk last night and not waking up. Or at that moment in time, so they thought. Then DM takes the phone and asks, "Can I just tell you what happened?" The dispatcher cuts her off. "I need to know what's going on right now." Eventually, HJ confirms what's become clearer by the second. She's not breathing. That moment when the veil finally lifts and the realization hits that this isn't just a weird morning, that people aren't hungover or passed out or ignoring texts. It's raw. It's terrifying, and it's now part of the record. The court's decision to allow the transcript alongside the audio might seem minor, but it's a big deal in trial presentation. Jurors aren't just hearing panic, they're seeing it written out in black and white. That is weight. That sticks. But it's important to understand something here. The court isn't using this call to argue guilt or innocence. That's not the point. The call and the text exchanges are about anchoring the timeline. They help establish when things were perceived, how people reacted, and what the environment inside the house was like. It adds human texture to the forensic frame. And in a case like this, where the defendant didn't confess, where motive remains murky, and where the physical evidence is complex, that emotional layer becomes part of how jurors interpret everything else they see. And that's when things get tricky for the defense, because while these texts and this 911 call don't name Kohberger, they do something arguably more powerful. They lay bare the chaos of that morning, the confusion, the missed signals, the disbelief. They show a house in emotional freefall. And even though the defense might say that none of it proves her client was there or that he did anything, I'm sorry, Ann Taylor doesn't talk that way. The Kohbergers do. Sorry to you guys too. Actually, I'm really not. That's not really the issue here. The issue is what kind of credibility the jury gives to everything else once they hear those young women try to make sense of something unspeakable in real time. That credibility, how jurors perceive these surviving roommates, their trauma, their actions, and their tone, can influence how later evidence is received. Not because it's logical, but because it's human. And when someone says, I saw a man in a ski mask, and follows it with, I'm not kidding, I'm so freaked out, jurors tend to lean in. They don't forget that. And yet, it is just as important to note that the court didn't allow in, at least not yet, some portions of the 911 call that were deemed hearsay and will stay redacted again, unless the prosecution can show they meet legal standards for admissibility. That's the court drawing a clear line between emotion and evidence. Just because something feels important doesn't mean it clears the bar. And the judge made it clear. No shortcuts, no assumptions. If it's coming into this trial, it has to be justified, which is smart. You don't want appellate issues at the end of this. So now with these rulings, we have a fuller picture of the morning after. Not through the lens of prosecutors or defense attorneys, but from the voices inside that house. The words typed in the dark. The frantic calls for help. The long hours of not knowing. These aren't conclusions, they're context. And context in a trial this complicated is everything. The jury won't be hearing about DNA, phone pings, or timeline estimations. They'll be hearing footsteps in the hallway, the silence of unanswered texts, and a phone call laced with disbelief. And from there, they'll be asked to piece it together into what it all means. And when, exactly, everything went so horribly wrong. What are your thoughts on what has been admitted and denied in this case? Tell me in the comments section. Would love to hear it. And if you disagree, that's fine. But bring your argument. Don't just, you're so lying. You're so misinformed, and then you leave it. Okay, what am I misinformed on? What are we lying about? Because, look, from this perspective, I'm not lying about anything. I don't come on here to lie. I come here to bring you pretty much the raw information, and you do with it what you will. But if you feel that something is inaccurate, tell me. And you can't just be saying, well, it's crooked cops. Okay, well, explain. Why? How? Who's crooked? Why? What are they doing? Give me some information other than just wild accusations. We don't speak in bumper stickers here. So I encourage you to comment on YouTube, but let's make it a good conversation. If you're listening on the podcast platform, press subscribe there, please. And also do check out our YouTube channel where you can watch everything that we do and also join into that conversation. We'd love it if you did. My name's Tony Bruschi. Thank you for listening. Thank you for watching. There's a lot more to this case, and we will talk again soon.
Craving non-stop true crime updates? Press subscribe now and get the latest cases, analysis, and expert commentary delivered straight to your feed. Only from the Hidden Killers podcast and True Crime Today.